We're going to get started now. I know there are a few folks who are still making their way through security, but we don't want to delay because we know that a number of you have other important events to get to this afternoon. So we're going to go ahead and start, and as other folks come in, they will join our conversation. But first, let me welcome everyone to this session on the USMCA Rapid Response Mechanism. My name is Kathleen Claussen. I'm a professor here at Georgetown Law. I'm co-director of our Institute of International Economic Law. And we are delighted to host this conversation. I do so together with my colleague, Professor Alvaro Santos, who runs our CAROLA Center on the Rule of Law in Latin America, as well as our colleagues from El Colegio de México that have helped us to organize this with the generous support from a Georgetown Global Engagement Fund grant. So we're very delighted to have our colleagues here with us as well from El Colegio. And we have had a productive day, many of us talking about this issue that we're delighted to carry on now into the public space. So we know we have many folks who are watching on Zoom. And so welcome to those of you who are joining virtually. And again, to those in the room, thank you for being here. There's a great deal of expertise in the room, so I'm confident that we'll have a good conversation. Before I introduce our speakers and say a word or two about the rapid response mechanism, I wanted to pause to recognize the passing of a colleague who has been a giant really in the space of trade and labor, and that is from George Washington University, Professor Steve Charnovitz, who sadly passed away earlier this week. There have been some tributes to Steve on the International Economic Law and Policy blog. There will be more in the weeks ahead. Those of you who knew Steve would know that he was an incredible writer, academic, but also a wonderful mentor and contributor to the conversation on trade and labor, one of the first to be writing extensively about trade and labor in the NAFTA period. And then he continued to be, of course, very active in this space, talking about the worker-centered trade policy and beyond in recent years. So we were all, of course, very sad to hear about his passing, and we remember him and honor his legacy as we continue these conversations in this important area. So with that, we'll focus now our conversation with our four distinguished speakers. Let me briefly introduce them. They need no introduction. They will be known to many of you, but I'll just say a word about where they're coming from, and then they'll pick up the conversation from there. To my left, Daniel Rangel, who is here from the Rethink Trade group, who has done a lot of work on the rapid response mechanism together with workers and advocating for the use of the mechanism to address workers' rights in Mexico. To his left is Sandra Polaski. Sandra, who of course has a great deal of government experience in her background, working on trade and labor issues for most, if not all, of her career, and is now associated with Boston University. So we're delighted to have Sandra as well. Then to her left, Josh Kagan, who is now affiliated with the law firm Kelley Drye, and previously spent a lot of his career in the government working on the rapid response mechanism. So really the resident expert, having seen this grow from to nothing to a lot. So we're delighted to have Josh as well. And Ricardo Ramírez Hernández, who is joining us from RRH Consultores, and many of you will know Ricardo from his extensive WTO and Mexican government experience as well. So as you can see, we have an embarrassment of riches in terms of expertise present on our panel to talk about this important mechanism. And I know everyone in the room and those watching, likely you have some familiarity with the mechanism, but I will say just a few words about it for those for whom it is the first deep dive maybe you are having into this subject. So the USMCA, or the TAMEC Rapid Response Labor Mechanism, is an annex as part of the USMCA, the TAMEC, to the dispute settlement chapter. So an annex to the dispute settlement chapter is where you will find the description of what this mechanism is. It is a mechanism that has been, that is designed to allow the Mexican government or the US government, although I'm sure we'll say more about that in a moment, to address labor rights violations, principally that of the right to collective bargaining, the right to unionize in facilities on the territory of the other party. So it's the first mechanism of its kind in allowing one government to address these labor violations on the territory of another government, and to do so principally by, as you'll hear more, in a way, stopping goods at the border when there is a belief of a denial of rights at that facility. So if the government discovers, if one of the governments discovers a denial of workers' rights at a particular facility, it can stop the goods at the border and suspend liquidation, as we call it, in customs terminology, until that denial of rights is resolved. So that, in very basic, generalized terms, is the idea. But it's a very powerful mechanism, and having that commercial effect on an individual facility in Mexico, something, again, we haven't seen before, something that was the product of a compromise between Democrats, Republicans, around the time of the negotiation of the USMCA, together with, of course, the Mexican government. There is also a rapid response mechanism between Canada and Mexico, but it's this one, the US-Mexico arrangement, that's gotten the most use, with 32 different facilities or situations arising under this.
The U.S. Trade Representative. So I think that's important to know, because if we're talking about, why was the Biden administration so committed to this mechanism, I worked in under with or under, I think, 4 different U.S. Trade Representatives, and obviously they know international trade issues very, very, very well. But I never met one who was so interested and committed to and knowledgeable about labor issues as Kathleen Drye. And so I think that her understanding of the mechanism, her commitment to the mechanism, probably her personal investment in it, is a factor here. And then the last point I'll make is, I think that you have to look at kind of the bigger picture, or what is happening from the US perspective, at least, with respect to international trade around this time. So the Trump administration come in 2016 and essentially ran on this platform, none of these trade agreements are working. We're going to do trade completely differently. We're going to have something we call America First trade policy, right? Then the Biden administration came in and said, actually, we kind of agree with some of what you're saying. We agree that these trade agreements this trade policy and these trade agreements haven't been working for the United States in the way that we want them to. But we have a different solution to the problem. And the solution that the Biden administration was putting forward is what they called worker-centered trade policy. So that was the thesis was basically having a trade policy that is having workers and workers' organizations and unions at the table for decision-making processes, and that is attempting to effectuate results that are creating positive outcomes for these workers. The understanding being the past trade policies maybe had been macroeconomically beneficial for the United States, but maybe not for a lot of these, especially blue-collar working communities. And so Kathleen mentioned, there was a move away from negotiating broad, tariff-producing free trade agreements, comprehensive free trade agreements, and so that was definitely part of it. There was a commitment to having workers' organizations and unions more integrated into a variety of the trade policy advisory committees that the U.S. Trade Representative's Office consults with. But you needed a proof point for actually accomplishing something, right? I mean, I think like the negative agenda is one thing and the inclusion agenda is another. But I think you needed some sort of positive proof point. You could say, we're actually accomplishing things. And so the RM really became that for the Biden administration's trade policy. It became the proof point for actually being able to point to specific results that had been achieved through this worker-centered trade policy. Kathleen mentioned, 32 requests for review. I don't have the stats in front of me, and I seem to be the only one who's not smart enough to have notes in front of me. But but tens of thousands of workers, the Biden administration would tell you, benefited from the RRM. New collective bargaining agreements, double-digit wage increases, dozens of workers being reinstated who had been legally dismissed. So I think there are a number of data points that you could point to say this actually was a different way of thinking about trade policy that was specifically focused on workers and workers' rights. And then I think the other piece that maybe the Biden administration could have spent a little more time making is, how is that benefiting U.S. workers? And I think that's kind of where a lot of the conversation is now, is the outcomes I think are there from on the Mexican side, but I think the full thesis needs to be, and that is beneficial for fair competition in both countries that's not based on things like reduction in labor rights. So I think to answer your question, having something that could be kind of a proof point for a worker-centered trade policy was really important. And the last point I want to make is, I think the ability to do that, and especially the ability to do that on the timeline that the Biden administration wanted to do it, which is really fast, requires a lot of resources and requires a lot of people. And so I think one reason that the results were what they were was because the U.S. Trade Representative's Office and the Department of Labor were able to work very closely together through with Department of Labor staff that were stationed in Mexico to gather some of the information and engage with stakeholders through a lot of what we call technical assistance funding, grants essentially, that were supporting this kind of work, educating the Mexican business community on how to comply with these sorts of rules, helping create the capacity of worker organizations in Mexico. And so I think the technical assistance piece is a really important part of this overall equation as well. And unfortunately, it's one that we've seen recently cut by the recent Trump administration.
Thanks so much, Josh, for kicking us off with that perspective. And you mentioned this commitment, very strong commitment among those who were in leadership at the time toward Mexican workers' rights. And so trying to imagine now that, so that's the U.S. perspective, U.S. government perspective. Now we're trying to put ourselves in the shoes of the Mexican government perspective. And of course, the Mexican government, we've had a couple of different leaders in place in the Mexican government in the last few years. Now, Ricardo, maybe I can pose this question to you, although you are not presently in the Mexican government. What can you tell us about what has been your impression as to how the last Mexican president, the current Mexican president, have engaged with the U.S. government on this particular mechanism? Do you feel the same sort of warmth of feeling that Josh described in seeking to help Mexican workers? How have the last 4 years gone?
Kind of, and thank you for the invitation, Kathleen, Alvaro. So, I think in order to assess what the perception now, you have to start with the expectations, and you have to start thinking about what was created, and it was created something that has never been created before. And for those students who are here, imagine for the first time you had given a right of a sovereign state to sue a company, not a company, a facility of a company, because they have not complied with the local labor laws. So it was a shock for Mexico, and there was a lot of expectation of what would happen. And I remember there was a lot in the news at that time that they were going to be flooded by people from the U.S. going in and inspect every facility, and there was going to be a mess, and all our labor laws were going to fall. And there was a lot of skepticism and a lot of saying what is going to happen. But at the end, if you start from that, and I mean, we will talk about other things about the system, but talking from a government of Mexico standpoint, I believe the government looking at now, I think you have to put it as a success story. Because I think of those 32 that you were talking, cases or situations or whatever you want to call them that have been initiated, the government of Mexico has dealt with them swiftly and expeditiously and effectively in most of them. So at the end, all this afraid that was in the room about the system, I think the Mexican government has dealt with most of these cases in a very good way. That's the first actual success that you can take from the system. But the other is the perception that has been created in Mexico, which is, in the end, there is this perception. I don't think we have numbers, neither of us have numbers on this, but there's this perception that this has improved the rule of law with respect to employees association issues. And at the end, I think that's good. And if you look at, again, from the government standpoint, I think you have to portray this as a success story that help address these things. Of course, there have been panels of those 32. I think 3 or 4 cases have gone to panels. But if you look at, and sorry, I have to bring it up, but if you look at the WTO out of 600 disputes that been initiated, half of them finish in a panel. Or I mean, not half of them, but a lot of percentage of them. And if you look at this system, the fact that only very few of them have reached that stage, I think it's a good sign. And it is not that it is a great deterrent. And I think we were discussing this in the morning. It's not that you will be taken to a panel. It's the threat of being taken to a panel that makes it enforce it, and people enforce it. And I think from a government standpoint, again, I think you have to be happy for how it has been worked.
So, okay, that's a very rosy picture we're getting so far from our two quasi-government voices here. Things have been going so well. Well, let's see, Daniel, tell us your thoughts. You have, as I mentioned at the outset, have been involved in filing petitions, right, on behalf of a number of workers who have been experiencing harm. So tell us, if you would, more about your organization's experience over these last 4 years. What have you been asking for? How has it been going? What have been the challenges that you have faced in trying to get, have all the workers been helped as you would have liked? Tell us.
Sure, thank you for the question, and thank you for the invite. It's always good to be back to my alma mater where I did my LLM. So I actually had an international trade course here in this room.
It was all planned.
Yeah. Well, I would start by mentioning some of the situations that actually justify the use of the mechanism by the union that I have worked with and with by the workers. Because for people that are not as familiar with the labor relations issues that are prevalent in Mexico, this might sound a little bit abstract. But basically, the kind of issues that have been discussed in the rapid response mechanisms are related to very serious violations of the right to freedom of association and collective bargaining, and they include mass layoffs or firing of union leaders when there's an organizing campaign. We have also found cases in which there has been an intervention of local authorities that have supported companies in cracking down on unions. And this could be either by not acting on the legitimate legal actions that have been started by unions, but also in certain cases by prosecuting workers when they have tried to exercise their rights. Blacklisting, which is a sad common practice in Mexico, that is when a worker tries to organize a union, then they are fired, and then they are denied employment at other facilities in that same city, because most of them are controlled by the same, in Mexico they call it protection union, a corrupt union, a union that in reality is working with the employer and is not representing workers. So blacklisting is a very big issue there, and we have tried to address this issue through the mechanism. Also cases in which the company has tried to impose a union on workers that they control and is not representative and is not democratic. So being able to use a corporate accountability tool in a trade agreement that actually gets into this kind of behavior has definitely been absolutely amazing. I think that that is one of the most important innovations in international trade law in the past couple of years. And I think that we all agree on that. So I think that as far as being able to use the mechanism, being able to have governments that are interested in making it work and redress these violations, I think that that has been great. And in most cases, workers have had material gains. As Josh mentioned, people have been reinstated to their jobs, and new collective bargaining agreements have been signed with substantial wage increases. So in that regard, I think that that has been very good. Now, I will be remiss if I don't say that there have been challenges. I think that one of the most important challenges that we have seen is that in the cases in which the company could shield themselves behind a secondary actor, like the protection union or even local courts, local authorities, I think that that has been hard to get the right kind of outcome, despite the fact that I think that there's something very good about how the mechanism is written. And it says that whenever a government has the belief that the workers at the facility are being denied their rights, the mechanism should apply. That means that there's no attribution requirement. You don't need to have proof that the company is behind the violations in order to use the mechanism. But I still think that we have faced challenges there. The other aspect of the mechanism where we have found a couple of challenges is in the remediation plans and in actually getting more involvement from the petitioners in what actually is done to remediate or to fix the situation that led to the activation of the mechanism. And the last issue is what happens with recurrent offenders. So when you have a company in which you have activated the mechanism, there's a remediation action, but then the underlying union busting strategy from the company is not addressed. That's very concerning, particularly because I think that it emboldens the people at that company to continue doing what they're doing instead of actually trying to resolve the labor issues that trigger the mechanism.
Thanks, Daniel. So we'll come back to some of those challenges in a moment, but let me get Sandra in here because Sandra, you've been involved in and written about this trade labor linkage for 25 years. You started when you were 5 years old. And so you have a lot of thoughts, I know, on this. Now, Daniel was just mentioning how this is a corporate accountability tool, right? This is something that really broke from the earlier, some would say, path-dependent U.S. approach to enforcement on labor obligations in U.S. trade agreements. So instead, everybody's got this entirely new approach. So what's your perspective on sort of how we got to this point, why this was created this way, and whether it's worked as intended?
Well, thanks, Kathleen, and thanks for inviting, and good to see all the people here. I understand we have a whole group of Mexican students who are here, and we're really happy to have a chance to talk with you and hear your questions as well. So as you've already heard from Josh, the U.S. has been linking labor rights to trade agreements for about 30 years now, starting with NAFTA, which was a side agreement. And the reason originally why the U.S. government did that was because trade had become very controversial in the U.S. It was seen as facilitating the offshoring of jobs, U.S. companies closing plants in the U.S. and moving them to Mexico or Chile or China or wherever. And so it was very politically controversial, and it was hard to get trade agreements ratified by the U.S. Congress. So when NAFTA was negotiated, the controversy level was extremely high. And so the then Clinton administration said, well, we're going to create a side agreement which will require Mexico to respect worker rights and its labor laws. And we'll enforce it through a mechanism between the two states. It was a very weak agreement. The protection of rights was weak. The enforcement mechanism was weak. Gradually over the next years as we negotiated, I say we because I was in and out of government those years, as we negotiated additional trade agreements, We always included labor clauses, but now instead of side agreements inside the main body of the agreement, and increasingly being enforceable through the same dispute settlement mechanism that would apply to any other dispute over rules of origin or intellectual property rights. So the state-to-state dispute settlement mechanism. So this went on, we kept on doing that. The first time that a case actually got to such a dispute settlement panel was between the US and Guatemala under the CAFTA, Central America Free Trade Agreement, and also Dominican Republic. And the US lost the case. And that was a bit of a shock. I think people who had been advocating for stronger and stronger protections of workers' rights and trade agreements saw that problem and began to identify that one of the problems was there was a real mismatch between the obligation to protect workers' rights and the level of the dispute settlement mechanism. So in the private sector, if workers' rights are violated, typically it's going to be by the act of the employer. It's the employer who fires workers. Many workers have been fired in cases that we've been dealing with in the RRM, fired them because they began union organizing activity. And it doesn't just happen in Mexico. I mean, it happens in the US and other places, but let's focus for the moment on Mexico. So it's the firm, it's the actual management of the particular firm in a particular facility hears about union organizing and picks off the leaders and begins to fire them, or otherwise intimidates the workers. Yes, there could be a corrupt union involved. There very often has been in these cases, but the union doesn't fire the workers. It's the employer. The union doesn't create, well, the union may create an atmosphere of fear, but the fear of job loss is created by the employer. So this mismatch between saying that the dispute settlement has to be at the level of a nation state government, but the problem is actually occurring only in one facility of one firm in one sector. Why would you want to escalate to the level where you're saying this is a failure of the government? No, it's a failure to respect the law and the rights by the particular firm. So we really recognized after Guatemala, and increasingly, I think there was recognition by both parties in the United States, regardless of who was in the executive and in control of Congress, that we needed something that would actually be an enforcement mechanism that was much more precise, much more tailored to be able to go very quickly to the source of the problem and to limit any spillover effects. So we were not accusing the Mexican government of the failure. We're saying this particular factory did this and we want to remedy. So that was the main thinking, Kathleen. There was the additional factor in the case of Mexico, which has already been referred to, is that over the decades, the labor relations system or industrial relations system in Mexico, in some cases, in many cases, Arturo Alcalde is here and he has written books about this, had become corrupted to the point that there was collusion between the employers and these corrupt unions to say there's a union here, an independent union can't come and organize because we already have a union, but the agreement would be made behind the workers' back. And in most cases, it was only whatever was required by the law, the minimum wage, the minimum protection. It was not real unionism. And for Mexican workers, most affected by this, what it meant was that there was systematic wage repression in Mexico. For a number of decades, there was also systematic wage repression by the government of Mexico during the neoliberal period of export-oriented strategy, keep the wages low to be competitive on global markets and with the US. So that you had this additional problem that you had this collusion going on in Mexico, which was creating an artificial barrier to workers to exercise their rights. So once again, how did you want to deal with that? Well, you could go escalate to the level of the government, an entire nation state, or you could say, let's look at the particular factory and firm where this is happening. We'll narrow our focus. The investigation can go very rapidly because it's a very precise focus. And so that was an additional reason why this new mechanism was created. It's already been said that it's unprecedented. There's no other agreement that has it yet. And in principle, it's, I would say, it's a very logical way of dealing with how do you enforce the labor obligations of the trade agreement. Now, your second question was, is it working as intended? Well, we've heard a lot of good things, and I'm happy to see that that all the panelists here agree that a lot of good things have come from it. It's worked well on the front end. And let me say what I mean by the front end. The front end of the RRM process is workers can submit a petition to a government saying our rights have been violated, and the government will investigate. A government can act on its own to say, we observe that workers' rights have been violated. We're going to raise this with our counterpart, Mexico. So at the petition level, at the initial investigation level, at the level of the initial discussion, conversation, consultation between the US government and the Mexican government, at the level where they together or separately develop a remediation plan to correct the problems, to get the workers rehired, to give them another vote, to determine who will represent them. And in many, many cases, in the actual implementation then by the company, by the firm of the remediation plan, it's been working pretty well. There's problems, but there's been a lot of victories, a lot of successes. And so that's what I'm calling the front end of the mechanism. The mechanism also has a next stage, which is suppose that Mexico and the US don't agree that there's a violation, or they do and they fashion a remedy and the firm does not implement the remedy. How do you get to the next stage, which potentially could involve losing trade benefits, losing the preferential tariff terms of the agreement, or for repeated offenses, actually losing access to the US market? At that stage, what finally came out of the negotiation between the White House and the Congress before they began to negotiate with Mexico, or while they were negotiating with Mexico, was a process called a labor panel. So it was like an arbitration panel of labor experts who would be assigned to verify whether there was a violation of rights and whether or not that had been corrected. We are just beginning to have experience with that now. So we had one case which has gone all the way through the process. The decision came out, I think it's about a year ago, a little less than a year. A second case has been in process for many months now. We don't have a decision yet. And now there's 3 or 4 other cases going in. What I think we're beginning to see, Kathleen, to your question of is it working as intended? That stage, that labor panel stage, I don't think is working as intended. I think there is a design flaw because instead of these very rapid resolutions, remediations of problems, which typically have been taking only 3 or 4 months, instead we're seeing 8 months, 9 months, 10 months, a year, more than a year, a big slowdown at that stage. We're seeing that the process is becoming very judicialized, very formal, very technical, not speedy and effective. And we're seeing what I would consider to be sort of a perverse reversal of incentives, which is that at that stage, it becomes like a state-to-state dispute settlement mechanism. Mexico is defending everything that happened because it's now in this dispute settlement, and the US is attacking or prosecuting everything that happened. It's not supposed to be that. We have a state-to-state dispute settlement mechanism in USMCA, and if the dispute is at that level, use that mechanism. It's very well developed, it's very well articulated. That should not be the approach here. And so I think that that part is not working well, and later in the conversation, maybe we can come back to some of the things that could be considered.
Thanks so much, Sandra. So great work. There's a lot on the table here already, but I'm going to do another round through our group here. Let me come back to Ricardo and then to Josh on the perspective in which you now sit. I mentioned earlier, you've both spent time in government, but now you're both working with private clients as well. So I want to talk about the reception of this mechanism by the business community. Obviously, they are the targets. It is a blunt instrument. It comes sometimes without warning. Right? We hear situations where the business did not know or they say they did not know that something was happening because, as was mentioned, sometimes the cause of the problem could be among workers, right, as compared to within the management. So Ricardo, starting with you, can you tell us a little bit about the reception, as I mentioned, of the mechanism by the business community? I'm thinking specifically about the effects that it has had on business behavior, on potentially on investment behavior. We haven't mentioned how some companies have closed when they have been targeted by this mechanism. There's been discussion whether some would leave Mexico as a result of it. And one last factoid to throw out there is that of the 32 situations we've seen, 72% of them have been in the auto industry. Now, autos have been in the news for other trade reasons lately, but that's definitely been a target sector under this mechanism. So from among those things, Ricardo, give us your thoughts.
So let me try to address them. First, what do we consider the business community? And it's important that you know that the business community is not Mexican companies, because I mean the 32 cases involve American companies, involve Asian companies, and European companies. So the first misperception is that this is about Mexican companies. No, it's not about Mexican companies. It's about Mexican, American, and European and Asian companies. So that's the first thing. Now, the question is, how broad is the business community aware? Well, what I learned this morning is that we don't know. It's not clear how much companies are aware of this, how many Mexicans, multinational companies are aware of this. I can imagine that in the auto sector, in the auto parts sectors, they are very aware because they have been targeted a lot of times. But we are not still not sure how this awareness, and there are no numbers of how much is this a perception. I always get the sense that people that know the systems are labor or trade geeks, and that's it. So we still don't know exactly how is that. Now, there is this perception, and again, this morning I confirmed that. First of all, that this issue about investment going out, I mean, when you initiate a case, there was at least one very known case where the company just said, no, I will not comply, and I will take my things and leave. I don't think that's what the system was designed for. And I think those are the things that you need to think about when you are trying to address or redesign this. And I'm sure that the company didn't say, I will not, because I will not comply with labor laws. I think there was something there in terms of burden, in terms of requirements, that lead that company to say, I'm going to leave. Now, we have to accept the fact that it's a very intrusive mechanism. And also, I learned this morning, and I confirmed that there will be U.S. inspectors going and ringing at the bells of companies and asking them, whether they comply with their labor law, whether the Mexican government whether the company is complying with the Mexican labor law. And that's also what the system was not designed for. This was designed to be a less intrusive, and I think, of course, if you talk about perception in the business community, well, that's a problem, intrusiveness. Another problem that also is confirmed by what we discussed this morning is the lack of transparency. And the companies are complaining about not knowing exactly what they are being sued about. And exactly, or not until they hire lawyers, good for us, but it's not what you really want or you envision in a system that you want to address. So, I mean, there are some flaws in terms of that. And the other issue, and maybe we can come back to that, is the liquidation issue, which is, and Kathleen explained it better than me, which is a system whereby U.S. Customs will put an burden on your imports into the United States. And a company doesn't know, I mean, it's discretionary. The U.S. government can or cannot do it. And there are no rules or when you can and you cannot do it. So imagine you start a process and you know immediately that all your exports to the United States will be hit by this liquidation, well, not liquidation. And so you will have a burden on you from that moment on until the problem is solved. And I think that also affects the business. I will leave it at that, Josh.
Josh, you want to react to any of that? You again, went from inside to outside pretty quickly. How has your view changed?
In the course of this conversation, I've gone from inside to outside very quickly, but sure, I'll put on my other hat. So I think a lot of the things Ricardo is saying is the same stuff you hear across the business community. I would say, I think understanding what I hear is less, a lack of transparency in terms of, we don't know what the government wants from us as much as like, we don't know specifically what are the rules of the road we're supposed to be following. I think it's, look, it's really easy to say like, you should follow the labor law, and you can certainly point to bad actors and say they're out of step. I mean, those are easy cases, right? But there's a lot of nuance to this stuff. And so I think there are a number of cases where, probably they're not doing things the way that they should be doing them. And, there are, a variety of advisors that can come in and help them clean that up. And that's one of the things that we work with Mexican labor law firms to help advise clients on. But I think, in that nuance, just making sure they understand exactly, is the RRM applied just to the new Mexican labor reform? Does it apply to all Mexican labor laws? Does it apply to, what's the specific scope they should be applying? So again, like, clearly, like, you shouldn't be union busting, you shouldn't be blacklisting work, and a number of the things that Danielle ran through, you shouldn't be doing those things. That's a no-brainer. So anyone who says like, oh, I didn't know I wasn't allowed to do that, that's ridiculous. But I think there's a lot of nuance here, and so making sure that there is a clear understanding of exactly what's within scope and out of scope. I mean, even the United States and Mexican governments were not aligned on this, right? They filed briefs in the one case that's gone all the way through the panel process with completely different understandings of the scope. So I think, clarity on exactly what is expected is one thing that we hear. The other is, and it's actually been mentioned a couple of times on this panel already, the way that the mechanism is focused is on a denial of rights of workers at a covered facility. It doesn't matter who commits the denial of rights. So one of the very early cases was a really high profile case involving one of the biggest US companies that was bringing very high value products, producing them in Mexico, bringing them in the United States. And the actual denial of rights was that basically the incumbent union at the time, they had to have a mandatory election under Mexican law for recognition of which union would hold the collective bargaining rights. They found out they were losing, and they destroyed the ballot box. And they did it in front of a camera. So the company saw the video, the US government got the video. It was a bit of an open and shut case here, right? But this company is sitting here, and so as Ricardo mentioned, just to like kind of pull back real quick on the suspension of liquidation. So basically the way it works is when goods come into under the terms of a trade agreement, you're getting a market access benefit, right? So just to use cars as a very common example, like small vehicles, it's 2.5% benefit. So if you qualify for the USMCA, under the USMCA, if you don't qualify, you pay 2.5% tariff, and if you do, you pay 0. So basically, that's the incentive to play by the rules of the agreement, which in the case of the USMCA are myriad. And so, but when you bring goods into the country, there's constantly things going across the border. They're not saying like, stop, hold on, let me see how much you owe. Okay, go ahead and pay me. Like that would be way too slow a process for the way we want commerce to work around the world, right? So you basically, importers pay a bond. And the goods, and they kind of like scan it as it goes through, they figure out how much you owe, and then they pay you back on the back end for what your benefits should have been under the trade agreement. So when we say suspension of customs liquidation, what we mean is they're not paying you back on the back end. So you should be entitled under the terms of the trade agreement to this market access benefit, this 2.5% in the case of cars, for each of those cars you brought across, which might be hundreds of thousands of cars, tens of thousands of cars. You're not getting that money until the whole matter is settled. So another thing the business community wants, interestingly enough, is for the whole thing to be fixed pretty quick. So that's another point I think that we hear a lot is when I haven't had any cases that have gone to a panel process, so I haven't dealt with it. I'm aware of the dynamic that's mentioned. But I think that the faster the resolution, the better from the business community, the more transparency on what is expected. In terms of a proactive compliance mindset, the better. And I think, some sort of ability to kind of mitigate risk. If you're that company I mentioned who was sitting on, what was a very large tariff bill as they waited for the customs to be unliquidated or to be unsuspended, to be liquidated. And the wrong was committed not by you, but by a union that under international standards and Mexican law, you're not supposed to have anything to do with. It creates a challenge for figuring out how to address the issue expeditiously in a way that's not violating any of your legal obligations.
Okay, there's still a lot there to further unpack. Let's stick with the topic of the panel now, because this has come up several times. And so, Sandra, you're saying that you're quite concerned about the panel process, that it's slowing things down, which is something that Josh confirmed, right? That if a company really wants to get this resolved quickly, you're at a panel, it's slowing down. Okay, so there's the speed issue. You also mentioned, Sandra, the judicialization, as you used the term, saying that this has become a state-to-state dispute in an environment that was intended to be a facility-specific, quick action, and so that's changed the vibe, so to speak, a little bit. So we've had the one panel, we said that it was involving this San Martin mine. And maybe we should add that the outcome of that case, this dispute, was that essentially Mexico won. I think it's fair to say, right? In the sense that Mexico prevailed in convincing the panel that the situation at the mine fell outside the scope of the mechanism. So, in other words, the United States had gone too far, was Mexico's argument. And the panel agreed. This was not covered by the terms of the treaty. Okay, so we've had this one experience. Now we've got the other one panel moving along. We're waiting for a decision in that case. We've got 3 more that have been set up or in the process of being set up. A question for anyone who wishes to respond and on my panel. The question is, how has the fact of having these panels affected the functioning overall of the mechanism? And you can answer that however you wish. From a worker perspective, is there some validation, perhaps one could imagine, that having a panel weigh in on the situation gives you more legitimation, more legitimacy in the process that was otherwise contested? You could see it from the business perspective. Josh, you said, yes, they want to resolve it quickly, but they also don't want to pay the bill. So maybe, again, having the opportunity to go to a panel and plead one's case, although the company doesn't have necessarily a voice in the panel process, as has been pointed out, maybe that could cut both ways, right? One could imagine that. And from the perspective of the governments, this is a huge burden to litigate this, right, before a panel of experts. So who wants to jump in on this and sort of additional perspectives on the panel process?
No, 2 things quickly. First of all, the fact that you use a system makes the system credible. So I think from the system standpoint, the fact that you have a concrete decision by a panel is good for the whole system as such, even though I would agree with the flaws or whatever. Now, the problem is that this decision make evident a lot of the problems of the system that was created. And I'm just going to touch the issue of definition of what is denial of rights, what is the scope, in terms of how do I deal with evidence, how do I deal with a lot of things that I put the burden on that panel had to deal with without any guidance, and actually trying to bring these rules of a state to state to a system that was created different, that had different intention. So, and again, that is the problem. And if you translate that into what does that affect, it creates uncertainty. Because you are a company that is being sued by this. And if the rules were clear on the scope, on the process, well, it will make our lives easier to give advice and say, well, it's not covered, it's covered, you cannot do this, this is how the process will go. But if you are not certain, and that, hold on, we all knew that there were problems when the system, remember the system was created very quickly, and there were some things that said, okay, you have a lot of trade concepts, and you have labor lawyers, and with all due respect, I love labor lawyers. I'm not saying anything. No, come on, and I'm being recorded, so worse. So no, but it's a system that was embedded in a trade agreement. So maybe, and I will touch upon this. Maybe you want guidelines, and maybe what they lack of is exactly, for example, they were discussing a scope. That is more a jurisdictional issue than a labor issue. So that to me, that was a problem, and that transpired into a little bit of uncertainty from the business and lawyer community.
Yeah, I think that's right. I mean, look, it's hard to do a new thing, and I give everyone involved a lot of credit for getting to where it is now. I mean, I think that I would never have the expectation that we would sit up here and say everything is perfect, this thing that was just created out of whole cloth, a few years ago. So I think there is the room for improvement, absolutely. I think that, I agree with Ricardo, having, the very first panel that hears it, they're having to decide not just the merits of the case, but like basic evidentiary issues and jurisdictional issues, which is, kudos to them for taking on those big questions, but also a little bit unfortunate that those couldn't have been foreseen and predetermined. I think that having a panel process is probably an important part of the mechanism being operational, right? You have to have, and we haven't actually, I don't think we've talked about this, the remedies. So if there is a finding of denial of rights against what is called a covered facility, the facilities we're talking about, in the first instance, the first finding of denial of rights, that facility loses going forward its USMCA tariff benefits. So could be whatever the difference between the USMCA rate and the bound rate is, which I mentioned autos. Well, it's not even that anymore. A week ago it was 2.5%.
But just to pause you there, so that's true for goods that qualify under you, right? Of course, there are many goods that don't qualify, and there are services for which. What's the remedy for those? That
will be. We're all watching very carefully to see where the essential panel comes out. But so, or I guess what remedy is imposed if they make a determination. I don't know, right? So we'll see. But I think so. So that's in the first instance, loss of the USMCA tariff preference for that facility. And in the second instance, so that would have to be a second case against the facility or the parent company. It would be loss of the USMCA tariff benefit for similar goods from a parent company. So let's say it's a Ford plant that makes, the same type of car or the same type of thing. Regardless of where in Mexico they do it, they would lose their tariff benefits in the second instance. In the third instance would be prohibition of entry of those goods into the United States. So that would have to be the third case. So far there's been eight cases that have, through settlements, arrived at places where there have been admissions of a denial of rights by the company. No penalty, none of these penalties have been applied, but there's been kind of what we call the first strike that's been applied in those contexts. So if there would be a second case at those facilities and a finding of denial of rights, they would be going for that second tier remedy. So I think having that is kind of a necessary, logical part of the process. It doesn't have to be that specific remedy, but having some sort of penalty or remedy involved in the process is part of what makes it kind of the mix of negotiated outcomes and enforcement tool that I think it is. And I think it gets really interesting and potentially scary to see if/how it's operationalized in the new tariff environment we live in.
Coming to that in a moment.
Yeah, well, I won't get ahead of you too much, but I think, so I keep throwing around 2.5% as the penalty, but what if it's 50? So I think that, that's going to change a lot of the way a lot of folks are thinking about the mechanism, and it's going to amp up the anxiety on all fronts. And so we'll see how that plays out if it plays out.
Danielle, could I get your thoughts on the panel process and specifically maybe on Sandra's comment about this over judicialization? is your sense from a worker's perspective, from a workers' group's perspective, would this be better if there were it ended in pure, I'll call it fact finding or mediation, or without a sort of binding report, without these formal processes, written submissions, rules of evidence? Is there a common perspective from the community, for the worker community on this?
No. I don't think there's a common perspective. I think that some people in the labor worker community think that the panel is a guarantee, because precisely the ultimate result of some of these cases could be losing market access to the US. And a worker and a union that is representing workers at a facility that is exporting 80% of their production, well, they don't want to lose access. What they want is to have better wages. They want for the rights to be respected, and particularly in the current context, the idea of having an independent body that ultimately determines if there has been a violation of labor rights and authorizes the sanctions, I think that that's perceived by most as a guarantee, and that's something that is good. I do agree that the fact that in a way, all of the process slows down once you get to a panel is an issue, because I think that we are also looking for a little bit more guidance in how the concepts in the mechanism are going to be interpreted through these panel decisions, because that's related to something that I think that it is a flaw in the design, that before the panel stage, there's really no documentation available to the interested parties about how decisions are being made. And I think that that's an issue that could be resolved either through having the panel process be more expedited, or having more clarity on how both governments are conducting their investigations and making their determinations.
We're going to turn now to the rapid response part of the rapid response panel discussion, and then I'll be opening to questions from the floor after a couple more questions. So do be thinking about what you'd like to ask our experts. Josh, you walked us up to the line here on this question, and it really is the elephant in the room, which is there's been a change in administration down the street. And we are not in the same environment we were in when you were in government and when we had a worker-centered trade policy. We are the America First trade policy. I mentioned that, of course, there's been also a change in administration in Mexico, a little less recently. The question for each of you, then, I'm going to start with Sandra, and then we'll go down the back and forth down the line. How has this change in administration, how have the changes in both administrations, particularly the US, affected your outlook for this mechanism, number one, but also Mexican labor reform and enforcement overall? What should we even be talking about this? Should we all go home or go out for drinks? Sandra?
Well, it is very hard to comment on a policy that is different today than it was yesterday, and will almost certainly be different on Tuesday than it is today. So let me take a pass on saying how the change in the administration in the US has changed my views about this, because quite frankly, it has not yet changed my views. You know, policy making goes on for a very long time. It doesn't go on only for 4 years. And so let me set that aside, but I would like to say something about the change in the government in Mexico. So from a Mexican perspective, we heard a little bit in the discussion this morning, but I hear a lot when I'm in Mexico that there is a perception that this process impinges on Mexico's sovereignty. Mexican sovereignty is a very important principle for Mexicans. Sovereignty is a principle in many countries, but for Mexicans, Mexican sovereignty, because of their neighborhood, has been a very, very important principle. And at a time when they may be feeling that they're exposed or potentially exposed to some real coercion, wrapping sovereignty and everybody getting behind that flag is perfectly understandable. However, in this case, where we're talking about a mechanism which is designed to improve Mexican workers' rights to have independent unions that represent them, that raise their wages, that give them better benefits and protections on the job. Sovereignty is not a good lens through which to view this particular process, because it's the class struggle between the workers and the employers over who is going to get the benefits from the productive work that they do. I mean, this is in the US, in Mexico, this is the reality in the workplace. And so sovereignty kind of implies that all Mexicans are in the same situation. They're not. The employers in every country, US, Mexico, have more power in the workplace than workers do. They can hire and they can fire. So the role of the government, the role of law, the role of labor rights is for the government to put their finger on the scale in favor of the rights of workers. Why do I say all of that? At the very beginning, I said a big reason why this mechanism was invented was because of the collusion that was going on between some employers and some unions, and the fact that it was repressing wages, that Mexican wages were not rising for a very long time. Completely aside from anything the US wanted to do, the previous administration in Mexico, the government of López Obrador, recognized that the wage repression in Mexico was bad, not because it hurt American workers, it was bad because it hurt Mexican workers, and embarked on what everybody now acknowledges was a remarkable 6 years of dramatic increases in the Mexican minimum wage, which had in fact been repressed by the government, the minimum wage, not the negotiated, but the minimum wage had been repressed by the government, such that in 2018, the purchasing power of the Mexican minimum wage was less than it was in 1982. Decades of wage repression had impoverished Mexicans. The López Obrador administration took these dramatic steps and significantly increased the minimum wage. It's still not where it should be, but it's so far above what it was. I would argue from a Mexican perspective, now coming back to the RRM, to use Mexican imagery, that was the first story of the transformation. We hear from President Sheinbaum a lot about the López Obrador administration building the first story of the transformation, and she plans to build the second story. I'm sure you've all heard that imagery. The first story was bringing up the minimum wage. The second story is having really strong independent trade unions who can negotiate better wages, not for people who are at the very bottom of the minimum wage, but those who are at 2, 3, 4 minimum wages, who have somewhat more skills, but their wages have been repressed by this collusion. And so from my point of view, Mexico is the real beneficiary of this trade mechanism that helps them to do the job, which is in the interest of Mexico. And it's particularly important in my view right now because Mexico, and I think this is a sort of universal recognition among the commentariat in Mexico, Mexico needs to diversify its economy away from its extreme dependence on exports to only one country. It needs to diversify its economy through exporting with more trading partners. But the main thing that it needs to do and that it can do is to increase domestic demand. I mean, Mexico is a middle income country, and that's where you have to go if you're a middle income country, is increase domestic demand. Well, can this increase domestic demand? It's probably one of the quickest tools over and above the minimum wage increases to improve wages, to improve incomes, household incomes in Mexico, and increase domestic demand. So from that point of view, I really hope President Sheinbaum can build a second story of wages.
Ricardo, can she? What's going on?
Let me just put on a different view on sovereignty. Because to me, the problem of sovereignty is not in the clear-cut cases that just referred to. The problem with sovereignty is when you have a case where you don't know exactly, where you have a borderline. And instead of the Mexican authorities to say how the labor law is complied with, you have a panel of 2 Americans or 3 telling you how your labor law should be interpreted. To me, that's the problem. It's not in the easy cut cases. And we are having some of those where it's not the Mexican. And you add to that is not symmetric. And to me, that's another problem, because at the end, it cannot happen. I want to see what is the US perception about Mexican lawyers saying whether US comply or not with US labor law. And I can feel a little bit familiar on foreigners finding US law inconsistent with international agreement. So again, I think we have to, on the sovereignty, I think we have to, to me, it goes more to that than to, I think it's very good that we comply with our labor laws, and I will go for that. And I was being even bolder to say, okay, let's put all the agreement in, let's put all the obligations, but let's be symmetrical.
Daniel, what's your sense of the outlook now? Your groups you wait and see, you try and keep filing petitions. Are you getting some signals from the US government of some sort or anybody?
I think that we are gonna continue working, assuming that the mechanism is a useful tool until proven that it isn't. We are working in a couple of cases. We see that the people in government, they are still engaged and interested in working with us. We're just gonna have to try and see.
Josh, anything further you wanted to add on this question?
Sure. So I think it will depend. So part of it will depend on so I mentioned kind of the space between the USMCA rate and the bound rate is the kind of leverage or penalty that exists. And so that it will, from my standpoint, some of it will depend on where the dust settles on that. Because I feel like if you asked me 2 days ago, I would have told you, wow, like that 2.5% I was talking about now, let's have the whole conversation over, but it's 27.5%, right? But then there was an autos announcement yesterday, and the possible expiration of the USMCA exemption that I mentioned for that 25% on the IEEPA tariffs is potentially due next week. So this is really an evolving space, and I don't know how to answer the question in real time. I think there's 3 tiers right now, but that's my current understanding. But I think where the dust settles on that will be really important for whether this is a tool that becomes even more meaningful or just kind of like falls by the wayside. I think that's also tied into where does the USMCA review conversation go. So I just think there's a lot of variables on the table now. It looks to me like the Trump administration is kind of trying to stack up leverage potentially in the lead up to that conversation to try and get the best outcome they can. And then the last piece I'll mention, which is I mentioned earlier, but I just want to kind of reiterate it because I think it's really important. The Department of Labor's international funding that goes to Mexico has been a really significant part of making this work. And that is for a variety of reasons. But for example, how do workers in Mexico know this exists so they can file petitions, right? A lot of that is because the Department of Labor has used a lot of creative tools to get the word out and make sure that workers understand these are your rights. And if you have concerns, here's how you contact the Mexican government and SDPS, but also here's how you can file a petition with the Department of Labor under this process. So I think, getting the word out, making the awareness known about it, training unions. I mean, there was some talk about, the importance of independent unions in this space and kind of how that's part of the model for driving up wages in Mexico. But a lot of the training and the capacity building for independent unions has come from the Department of Labor in this funding. So the decision by the Trump administration to cut that funding is going to be directly tied to whether there are independent unions or many of them, or whether there are petitions. And so I think, that doesn't necessarily mean the game is over on this front. I think there could be more self-initiations. There could be, it would not surprise me, see the Trump administration targeting different types of facilities, less with a labor rights focus maybe, and more with an economic competitiveness focus. But I do think it's going to be a change in the process.
Okay, one more lightning round question, which is if things move ahead. So we're going to wait and see. We're not sure funding is obviously a big issue, but let's assume things move forward. Let's assume we still have the mechanism and that USTR and Department of Labor intend to continue to use it in Mexico. We've already talked about how Mexico certainly can't easily use it against facilities in the US. But if it continues to be used, if you had one thing that you could change about the mechanism is part of the USMCA renegotiation review process, what's the one thing that you would ask the negotiators to focus on to help the mechanism achieve the goals that you think it set out to create? Dan?
Just one. I will try to improve the consultation with the petitioners in when the remediation process is picking up steam. Because I think that consultation in that part of the process hasn't been great, and that has led to subpar results.
If I had to pick just one thing, and I have a long list of things I'd like to see changed, but if I had to pick just one, I would pick what is undoubtedly the most difficult and probably would be extremely difficult to achieve in the current US administration. And that is to address this question of asymmetry. In Mexico, workers who want to file a petition don't have to exhaust the domestic remedies before they go to the process. But to file a petition or to have a case in against the US, against a US company, you have to go through the entire National Labor Relations Board process and even court enforcement, which is what gives rise to this notion of asymmetry. Even though it's technically available in the US, it's such a delayed process because of having to go through domestic, the domestic exhaustion of remedies that undermines, I think, the appetite in Mexico at many levels, academics, government, advocates, business, certainly, that I think that reduces the appetite to value this mechanism. And so at some point, one day, when the stars align, we are going to have to get symmetry in this.
Yeah, and by the way, the Trump administration is not going to have many enforced NLRB orders. Yeah, I actually will go back to something Sandra said earlier, which I think is really important, and that is, I think the mechanism works well in the early stages when the representation for the company can play a key role in trying to resolve the issues. I think a lot of the success we've seen to date has been companies trying to do the right thing and fix the issue, maybe because they want to avoid the panel, maybe because they just believe in the issues, doesn't really matter why, but taking a proactive role. And then we get to a point where suddenly, too bad, now it's a state-to-state matter, see you in 8 months. And so I think if we really want it to be rapid and if we really want to effectuate positive results, then we should make sure that the facilities have more of a direct role throughout the process.
Can I say one that encompasses two, which is scope? And so it will mean I will make it applicable to all USMCA labor disciplines, in particular the immigration workers discipline, and to all sectors, in particular the agricultural sector.
All right, with that, I'm going to turn to the floor for questions from the audience. I know there's a lot of expertise in the room and a lot of curious minds. So who would like to ask a question? And we'll be sure to bring you a microphone.
My English is little, but my Spanish is forced. Soy juez de asuntos laborales. Yo capacité y formé a los jueces jóvenes como ustedes en este cambio en México que implica una manera distinta de observar el mundo del trabajo. La libertad sindical, la democracia sindical, la dignidad de las mujeres y hombres trabajadoras de las maquiladoras. Muchos de ustedes conocen las maquiladoras en México actualmente vive una primavera de los derechos laborales. Los derechos de las trabajadoras y los trabajadores han ido en ascenso. Surgen como las flores afuera. México tenía los más bajos estándares del salario en Latinoamérica. Solo Haití superaba a México. Cuando fui a Brasil, Brasil dijo, México tiene 2 meses de vacaciones porque aumentaron al doble de vacaciones. Solo aumentaron 12 días. Entonces, esta es una muestra de cómo el derecho internacional, el comercio internacional se relaciona con los derechos laborales y los felicito a todas y a todos por este panel. Muchísimas gracias.
Thank you, Sergio. We're going to pass the microphone to Professor Santos, please, for a question. Thank you for that intervention.
I want to thank the panelists for these really insightful remarks and observations. And I have a question for Josh, and then I have a comment. And the question is, if you see a possible scenario where the tariffs nullify the USMCA advantages to the point that they make the incentives to comply with the rapid response mechanism basically void, that they basically in some ways just neutralize the incentives that firms have to comply with the mechanism.
So first I'll say, whenever someone says to me, I have a question and a comment, it feels like a trap, so.
The comment comes afterwards, but it's unrelated.
Oh, I see. And the other thing is, I'm a trade lawyer these days, and I get asked all day, every day by clients, what is going to happen next on tariffs? And I can guess, but that's not a good use of anyone's money to pay me to guess things. So I don't know the answer to that question, but I would say, yes, it is possible. I think if they do not provide some sort of meaningful benefit for being an originating USMCA product, then all of the rules that you have to follow under the agreement are not worth it anymore, right? So whether that's the RRM or the rules of origin or a variety of other hoops you have to jump through. I mean, we talked about the USMCA being kind of the high water mark, and Sandra ran you through kind of the evolution from a labor standpoint, but I think it's probably also one of the trade agreements with the most rules in the world. So I think, there has to be a payoff for doing that. And it is certainly possible that they can create a system where it is no longer economically preferential to follow all those rules. I said I wouldn't guess, but I'll just speculate that I think that would be a pretty extreme outcome. I mean, there are just so many really important supply chains for the US economy that are based on some sort of preferential market access between the US and Mexico in particular, but also the US and Canada, and the three countries together in some cases. So I think what we've got right now is maybe something like a reasonably ideal outcome from the Trump administration standpoint, which is, like I said really briefly, it's basically 3 tiers, right? So tier 1 is you're outside the USMCA, either because you're not in one of those 3 countries, or because you are, let's just say, in Mexico but not meeting the USMCA rules, then you got a really high tariff burden. Let's say you're in tier, that's the worst tier, tier 3. Tier 2, you're sourcing from Mexico, your goods coming from Mexico into the US, and you are following the USMCA rules. There has to be a meaningful gap between 2 and 3, and I think right now it's 25%. Is pretty meaningful. But then for autos, there's a reason so much of the RM has focused on that, because it's such a highly traded sector and a high value traded sector between the countries. For autos, there is now going, as of today, or as of yesterday, basically an additional premium for US originating goods. So not just USMCA, but US originating goods. So basically the value of US originating goods comes in for free, and the rest gets this New Mexico autos tariff. So you essentially have a 3-tier system, and I can see a scenario where that makes economic sense, maybe pushes some investment to the US, but doesn't completely blow up USMCA supply chains. Maybe that strikes the right balance. I feel like it's pretty thin ice to be playing around with, but there could be something there.
Yeah. Can I just follow up really quickly? Yeah. So, and I think this is a really useful classification, the way you provided. But since we had seen threats to increase 25% on tariffs across the board, and we might see, other developments, I was thinking about the possibility that gap really shrinks and that the incentives are gone. The comments, it's more of a follow-up on the sovereignty point, and I agree with push for full reciprocity. But the comment was about so the way in which the Mexican narrative of the labor system that Mexico has is really a point of pride in, you know, if you read the Mexican labor law scholarship and you read Mexican labor law cases in law school, it's all this narrative about what came out of the revolution in 1910 and the way in which Mexicans were the first one to include labor rights in the constitution, even before the Weimar Constitution in Germany, right? So it's a narrative of pride in labor law and social rights in Mexico that then became completely, trouble, turned upside down, really corrupted. It became a simulation in many ways, right? And so it's kind of ironic that the way in which this could be re-jolted is through the trade agreement, but in some ways it's completely consistent with the, you know, sovereignty narrative that Mexico had always sort of prided itself off, right? And so I say this just because it's about complying with Mexican labor law, and it's also about sort of fulfilling this narrative that came out of that revolution that, you know, the Mexican government with the employers and the official unions had completely perversed.
Juliet is extended, Kevin.
Thank you to the panel. I have a quick question on the fact that the mechanism is facility specific. I think that Sandra mentioned that that helps us focus on where the problem is. But at the same time, doesn't that make the mechanism relatively very expensive with respect to the specific problem being solved in each of the cases? I mean, at the end, since each of the cases, I mean, is referred to a problem in a specific facility, that I would guess that is making the labor problem solving mechanism relatively expensive as compared to, I guess, possibly a national institution.
Perhaps it's not very efficient to go one by one and everyone takes huge government resources, right, to bring each case. So is that the tenor of the question, Julian? Yeah. Any who wants to respond?
Yeah, I would like to respond to that. So, as I say, the change in the RRM was accompanied by the change in the Mexican labor law, the 2019 profound changes in the Mexican labor law. One of the things that is going on is that the new institutions in Mexico, the Federal Center, believe that the Federal Center believes that it does not have the authority to impose sanctions on firms that violate the labor rights. The law is very clear that they have certain sanctioning ability, but it's very minimal. If an employer doesn't show up to a hearing, they can be wrapped on the hand with a small fine because they didn't show up. But to actually impose a meaningful fine for a company that has fired union organizers and favored a corrupt union and so on, the Federal Center believes that they don't have the authority to impose significant fines. That's a real problem. It's a real problem because it means that the incentive for the workers whose rights are denied escalate up to the RRM. It would be much, much better if the problem were solved in Mexico. You know, last year, I'm sure you're well aware, there was a law introduced and it passed the Chamber of Deputies to create this very explicit sanctioning authority for the Federal Center. It passed in the lower house and it stalled in the Senate. It didn't get passed. Probably some politics there, right? One would think. But that's a problem because it is an explicit obligation of the USMCA that the Federal Center has the authority to impose appropriate sanctions on a company that violates these rights. It's a violation of USMCA right now, today. And I'm just hoping that this law can be reintroduced and get unstuck. I believe if that happens, and if the Federal Center develops both the confidence and the competence to use that authority effectively, we will see a reduction in RRM cases, which would be much more efficient.
I just want to comment that I think that even though the mechanism is facility specific, that doesn't necessarily entail that it has to be one facility at a time. And if you are seeing like a pattern of violations that is affecting an entire industry, I think that it could be possible to activate the mechanism and trying to encompass a whole sector or like a large number of facilities. I think that that's something that would be interesting to see if we're seeing like these kind of like systemic problems, for instance, regarding blacklisting. And that's not related like to a sector, but more like a region. If we're seeing the case that we have seen the case in a city where the different facilities and different companies that are located there are all blacklisting a group of workers that try to elect their own union, then I think that that should be actionable through the mechanism.
Can I just add something real quick? I also think there's a demonstrative effect that you get, and I think from my standpoint, you know, when you're wearing my former government hat, you know, one of the things you're thinking about when you're bringing a case is you want to bring cases on kind of high profile contexts that are going to have a demonstrative effect for others. And so there was one case that was brought against, there are the, you may know this, but maybe the whole room doesn't. There are sectoral bargaining agreements for certain sectors in the Mexican economy that basically say, you know, you can have your individual collective bargaining agreement for your facility, but it can't be below this sectoral agreement. And so there's one in the rubber sector that covered tire production in Mexico. And so there was one RM case focusing on a particular tire company and saying your CBA is lower than the sectoral agreement. You need to at least bring it up to that. And they did. And it was like a couple $1 million of back pay they paid to their workers plus a double-digit wage increase going forward. But that was like, hey, you know, oh, pay attention, everyone else in the sector, you need to get on board with this or you're going to have the same risk. And not all of them did. And there's one that's going through the process right now, unfortunately, but some did. And I think, you know, when you have those sorts of kind of cases, it can have broader ramifications than just one facility you're looking at.
But what Josh and Daniel are saying trigger me to think, then if that were the case, why didn't the US initiate the state-to-state case? Because at the end, you're looking at industry sectors, auto sector. Why didn't the US put forward a big case on auto parts? They had the evidence, so they could have. I mean, I'm thinking of why you had the state-to-state system. Why didn't you use it instead of initiating 5 or 6 or 7 or 10 cases on the auto parts sector? I mean, to me, the problem maybe has to do on design. I would have thought that in order to initiate the state-to-state was designed for patterns, for systemic things. And the facility was for very focused cases. But what we're seeing maybe is that they are triggering sectors, but without actually engaging with sectors.
I think for one reason it's because there was a petition filed under the RRM. And so there are certain, the way it works under US laws, when the USMCA was passed, there was a US law, the USMCA Implementation Act, that put certain requirements on parts of the US government in certain timelines. So it is actually not within the US government's discretion to receive an RRM petition and be like, actually, we're going to treat it as this other thing. You know, they have certain timelines that are bound on them. And then I think also it's just a different timeline, different evidentiary standards, et cetera. But I agree with you for broad systemic issues.
Yes, just to interact, but the US government knows before that is filed. And again, there would have been an approach with the US authority, USTR, saying, okay, I'm thinking of initiating a case on one of auto parts. Okay, another case on auto parts. Then let's bundle them up and initiate one because you will comply the standard of a pattern of persistent pattern of violations of labor laws. I mean,
We could go on. Kevin is patiently waiting. Kevin.
Thanks. So my question concerns what are the incentives for companies? What do they care most about? I mean, every company cares about paying money, of course. But one of the tensions that has arisen in, and Kathleen's written about this in these panels in particular, is that they have a fact-finding function where they're supposed to issue a report of facts. And if the facts, and then they have an adjudicatory function where they make a determination of whether there's a denial of rights by applying the facts to the law. And if there's a denial of rights, then the US has the, that's what we're talking about really, has the ability to potentially impose these trade penalties of various degrees. But for example, in the San Martin case, at least according to the submissions of the Mexican party and the company itself, it had no trade connection with the United States, but it cared a lot about winning. So I'm wondering if the tariffs penalties actually mean much at all. What if we had a system where it was just a pure fact-finding mission, and all we had was a report, and tariff penalties didn't really have much to do with it? Would companies care? Would it be enough for them to comply?
With shaming, it'd be
The
enough.
name and shame,
Name and shame.
with a report with lots of facts, like an international fact-finding mission.
The ILO does that every year, and it hasn't been enough. Full stop.
Yeah, you need the hammer.
Yeah.
And the hammer is trade. And
It's in addition, I mean, yes, the ILO, also the OECD has a national contact point process, that's led by the State Department for the US government, does similar things, doesn't have the same level of transparency I think that you're talking about in terms of publication, but there is at the end of the process, publication of a report. Also in the Biden administration, you know, you saw a number of these kind of RRM light things, like I think there's a LRAB in the Indo-Pacific Economic Framework context. So I haven't seen any of those move the needle in the same way that the RRM does, so which leads me to agree that you need some sort of hammer.
excuse me, and has there been a case in the Indo-Pacific? No.
The question was for those virtual, whether there's been anything happening.
I was
Please.
wondering because I knew that in the Indo-Pacific, the Biden administration was trying to use the RRM and apply it, despite the fact that in the Indo-Pacific, there is no, as you know, there is no elimination of trade barriers. It's only sort of a consultative, and they are looking for another kind of incentives, like certain agreements of safe relationships, security relationships of different areas. So I wonder if you knew about a case in the Indo-Pacific. Is it going to make progress in the Indo-Pacific without the penalization that is utilized?
I'm not aware of any cases in that context. I also candidly feel like that entire exercise is probably on a bit of ice right now while people figure out if the United States is still committed to it. But I haven't heard anything about any individual cases.
Questions? Go over here. If we could pass the microphone, please, the long way up and over. Keep your hands up. I saw 2 questions. Thank you.
Could we know who they are?
Sure, if you want to introduce yourself, that would be appreciated.
Okay, hi, thanks so much for this. I'm Tim Herschel Burns, also with the Boston University Global Development Policy Center. So I wanted to ask about awareness and scale. So thinking about the RRM as a precedent for new trade agreements, but this model seems to depend so much on awareness for workers to be able to file petitions, for governments to have enough knowledge to investigate, for businesses to know enough about the RRM to be a deterrent. So, you know, in the Mexican case, there's a sort of empirical question about how much awareness there has been and what caused that. But if you're thinking about scaling up this model to trade agreements more broadly, I'm wondering how much you think there's a risk that you could get this on paper in various trade agreements and not much would really come of it.
Yes, there's quite a risk.
Yeah.
And even in Mexico, where I think there has been a lot of effort, we've heard about some of the grants from the United States going to groups that would publicize, but obviously the Mexican government has also played its part in many different ways about trying to publicize the information about this. What I think we're observing is that kind of education doesn't really sink in. I mean, it would be like if there were an education campaign in the United States about some particular aspect of Social Security, say, and until it actually affects you or somebody in your family, then, well, there was an education campaign, but I don't really remember what were, I'm just saying that where I think we see some impact now, though, is where you have an instance, an RRM case, but an instance where there is a challenge of a corrupt union by an independent union. Maybe the company's been in collusion with the corrupt union. It went to RRM. The result is that the independent union wins an election and gets a much better contract than what existed before. That tends to get reported in local media. So people in that locality, in that sector, I think tend to know about it. And the reason I believe that's happening is because even in the situations where you still have what are called protection unions that have not delivered for workers in the past, if a competitive union now enters an independent union and starts getting better contracts and people know about it, that protection union will probably negotiate a better contract next time around because they're afraid that they will be the next ones to be challenged and to be voted out and to lose the dues that they're collecting. So I think we're starting to see some local impact of it in some regions, but that's 32 cases, assuming every one of them has that kind of impact locally. There's a lot more than 32 localities and sectors in Mexico, but I do think we're beginning to see some impact for the cases that go through.
I'll just add, I think I completely agree. I think there is a real risk of having just words on paper if you don't have resources to implement for pretty much anything. Definitely this. I do think, I don't think there will ever be something that looks exactly like the RRM in another context. I think it is pretty specifically tailored to the Mexico-US dynamic. So like suspension of customs liquidation, I've mentioned it briefly before, but like, when a car is made between US and Mexico, it bounces back and forth across the border, I don't know, like 20 times, a lot of times. So every one of those times, that suspension of customs liquidation matters, right? If you're just doing a one hit transaction with some country on the other side of the world, it doesn't matter as much. Still matters, but it doesn't matter as much. So I think, just the way it's designed is pretty unique to this context. I think to the extent that there are future free trade agreements that go through the US Congress, which is an open question, I think they will have some sort of facility specific mechanism. As Sandra said, the trajectory is really in one direction. I don't think suddenly like this will all be gone, but I think it will, whatever it looks like, if we're in that sort of dynamic that involves the US Congress, I think it will be tailored to a particular context.
Last question.
Thank you. Hello, my name is Juan. I come from the School of Public Policy, your neighbors, and so not all the students. So I would like to take advantage of being in this panel to ask about the labor rights in North America. So you were talking about the asymmetries between the two countries. So I would like to ask, what are the main differences on labor rights and union, and how does that impact trade? If that can help us understand more what kind of asymmetry we have in North America.
How much time? I'm just putting your question, trying to put it in context. We were talking about asymmetry of the system itself, which, as it was correctly pointed out, it is available in writing for both countries. So in theory, a petition could come from Mexico against a U.S. company, against a U.S. facility in the United States. However, there's this famous footnote that makes it practically impossible to use the mechanism against the U.S. I mean, practically impossible. You tell me.
Very slow.
Yeah, very slow, to say the least. So that is the asymmetry we were referring to. At the end, just remember, these systems are to comply with the law of the labor law of the country. So at the end, you will have to comply with US law in the US, with Mexican law in Mexico, with Canadian law in Canada. So it's not, in terms of substantive obligations, we are not talking about extraterritorial or even international. You are subject to the disciplines of each of these the three countries.
And I would just add that the idea that the laws to be enforced are the laws that have been adopted by each country goes to this question of sovereignty, which, you know, is a through thread through all of these things we're talking about. At the same time, all of the countries in this agreement and in several of the earlier US agreements agree to respect the international principles that are set out by the International Labor Organization as applying to all countries, regardless of whether they've ratified agreements. And so there is at least a theoretical upward harmonization of standards that they should meet these ILO standards, which are pretty good. I mean, the ILO standards, if they were respected by the US, would improve workers' rights very substantially. True in Mexico as well.
I want to take advantage of that question because I do think that there are certain asymmetries between the protections in labor law in Mexico compared to the US that in a way have been hidden by the way in which like the narrative about the mechanism has worked out. For instance, in US federal labor law, agricultural workers are not covered. Domestic workers are not covered, and those kind of limitations are not in the Mexican labor law that in paper it has more guarantees. Also, for instance, the right to strike is better protected in Mexican labor law compared to US labor law at the federal level. And I think that all of those little differences are masked by the problem of the lack of asymmetry in the design of the mechanism, the fact that advocates, we cannot use this tool to say, hey, in the US, there are also union busting campaigns, and they should be addressed, and they also have consequences in international trade.
I'll be brief, but take a slightly different view. Yes to everything that was said, but also I think when we talk about the asymmetries in the mechanism, which are true, I think we need to remember the context that this is happening in. The context this is happening in is a trade negotiation between two countries. And, you know, if you haven't heard, there is a trade deficit, which means one country there's a differentiation in the imports and exports from the two countries, right? So I think that does not equate to an equal trading dynamic. And so I have, totally be aspirational, ask for reciprocity, ask for equal treatment in both directions. I don't see any reason not to do that, but also just from a pragmatic standpoint, the countries are negotiating this coming from different places economically in terms of the dependency. And so I think that is why you're getting different results.
So we have come to the end of our time. This has been an incredibly productive, fruitful conversation. I know that everyone in the room and everyone watching online has learned a lot thanks to our experts. In this moment of great uncertainty, of change in the trade policy landscape, we will all wait to see what happens with this mechanism and with the future of US-Mexico conversation on labor issues. But I again want to thank our panel of experts for really laying out these issues in a way that was very helpful to all of us. So please join me in thanking our wonderful experts.